Yes, they have a right to punish.
Because some people say that if the prosecution did not agree, why didn't they go to the Court of Appeal?
The issue of appeal, you know, on sentencing, I don't know the legality or the acceptability of appeal on sentencing. What I know that prosecutors usually appeal against is issue of conviction. Whether you didn't convict, but now the man has been convicted. The issue was issue of sentencing. I don't know the legality of appealing against sentencing by a prosecutor. So that's why they had to now look for another, a charge to hang on his neck and discover that he didn't make full disclosures of all the properties actually acquired illegally. So they now slam him with that charge. So the point is that it's not everything you begin to, you see, justice, as I said earlier, is very key. And we must be seen to do justice. And everyone must see it. The moment you begin to, believe in this issue, why didn't you go and appeal? And then judges will begin to make some mockery of justice, making pronouncement, that does not in any way tally. And the people will begin to look at judiciary as something that is, what is wrong with these people? We should not allow that to happen. So I think the NJC was right in ensuring that there is sanity. Not the question of, a judge can err on facts and law, fine. And you know that he is a human being. You can appeal on that. But not when glaringly you see that a judge has made a pronouncement that does not tally with the essence of justice. And this is what has happened.
Just quickly, some people believe that there should be no middle ground for judges. It's either when they have erred, I mean, especially when it's something maybe that looks like corruption or looks like maybe not exercising their discretion properly. There should be no middle ground. It's either they're dismissed or, they're left there and say that they didn't find anything against them. Because they say that it will affect the morale of those who will come before them, and those people would not be sure if they will get justice.
The point is a point of view. Another person will look at it from another point of view and say, even God himself, that is a God of second chance. He gave David a second chance. Now, if you err as a judge, it depending on the gravity of the offense, and the NJC look at the entire fact, listen to all parties and say, look, this thing is not grave enough to ask him to go. Let's give him an opportunity, again, to still be a member of the bench, but there must be a punishment 1 year without any pay. They have a discretion. It's all based on facts. It's all based on the circumstances. It's all based also on what they have at the back of their mind before making their pronouncement. So there is always room for second chance. So I am saying that this is the first time it has happened. There may be a reason for that, and they have already told us that the man exercised discretion. Not that he was caught with another person's wife, not that he stole any money, not that even money was even alleged to have given to him. They didn't prove all that. But the point, the issue of discretion, he exercised it wrongly. So why would you now go ahead and say, okay, based upon that, I dismissed him completely and all that? So there are facts before they took that decision, and I won't fault it.
Yeah, I want to go with some other lawyers now. Perhaps you tell us what you think on that. Yes. They say, well, judges shouldn't have what they call second chance. If you've erred, and you should be asked to go. How would you feel as a lawyer when you stand before such a judge after 1 year that is back on the bench?
Yeah, if he has been punished with 1 year suspension, and as I said earlier, he was not alleged to have been caught even with another person's wife, but that in exercise of his discretion, he exercised it wrongly, I will feel confident appearing before him. In fact, you will make the judge to really sit up and be very, very mindful in his subsequent pronouncement, knowing fully well that he has been punished before for exercise of discretion wrongly. So I will feel confident appearing before. I don't see anything wrong with that. I'm saying that, well, judges are human beings still. You make them look as if they are God. No, they are not. They are human beings also who are amenable to mistake, which the man made, and the NJC said, look, you made a mistake here, but we are punishing you. But the punishment is not retirement. It's not compulsory. Go home, but you'll be suspended for 1 year, and you come back to the bench, and then be careful. Be careful in whatever you do from now onwards as a judge. I don't see anything wrong. It's this exercise of discretion. Not that he stole money. Not that he was caught with any committing fraud and all that. But issue of exercise of discretion, which NJC said that he exercised wrongly. So to me, as I said earlier, I believe in God of second chance, and this man has been given a second chance. And I think he'll be very, very careful from now onwards.
Well, there are those who also point out two key issues here. They think that the NJC has not even addressed the matter. Because other than them thinking that this does not deter, because in the first instance, if you suspend them for 1 year, is he going to be getting remuneration, or at the end of the day, he still comes back, he carries on? You have other judges who say, okay, well, if that's the punishment, hey, who knows? If and only if, because yes, nobody has proved any bribery allegation, but some also they say because it wasn't investigated. If it wasn't investigated, you never know what you may find. So on that basis, some people think 1 year suspension, you go back, you're doing the same things, not deterrent.
As I said earlier, you didn't hear what I said is that what actually impeached the mind of the NJC before saying, look, this man go 1 year. There must be facts. There were facts before them. They did investigation.
Could it be that they couldn't go beyond that, or what? Or
no, they could have asked him to go, but they felt that based upon the facts before us, you met out punishment based on facts. The facts before them was not grave enough to say this man be compulsorily retired, just as they did with Justice Okeke.
What does
some people wrote petition and said, Justice Okeke, you go only. I mean, you be warned. They warned him.
When you say based on the facts before them, do they carry out the investigation themselves, or based on what the petitioners present before?
No, the petitioners wrote, and then they must have called him. As issue of fair hearing, it's very key in things like this. They must have called Justice Tauba and said, based upon this petition, can you make a response to it? And he must have given his response. And they must have also invited the prosecutor himself that was involved in the entire decision. And he had all the parties. It is based upon this thing they have here that made them now to make the pronouncement about the punishment on him. So facts are very key. So it could have been grave enough and they said, look, go. But to them, the only punishment that is, commensurate to the punishment is, alleged crime. At this point in time, is just 1 year suspension. So I think it's the fact that really determined that.
Can the NJC say, well, yes, this is what the petition is about, but just to make assurance doubly sure, let's be sure that there isn't more to this than meets the eye. We'll institute an investigation and find out if there are any other matters which we can action upon.
Yeah, we can determine the procedure they use in investigating any.
No, I'm saying, can they do that?
Yeah, they can. They can't go further. They can't go further. It's all left for them. They formulate their rules of proceeding. They are the one that is in charge of all that. They don't know what to do in order to get to the root of the entire matter. That must have been a petition somebody have written against Justice Tauba. They must have also called him. They must have also called other auxiliary witnesses in the entire thing. It's after all that then they now see, look, we feel that this is what is commensurate to that particular crime.
Do you think the NJC should have even looked beyond and find out if there was any sort of corruption involved in this?
You think they didn't do that?
Do you think they should have? Or
they should have. But they also should have. Maybe. But I can't stay here and say that they didn't probably look into all that. And they didn't find any shred of evidence. Because it's also key that we must give them the benefit of the doubt. They would have, probably, okay, they won't investigate any allegation that is not alleged. If somebody has not alleged any issue of money passing through,
no, but
you must provide evidence.
Does somebody have to allege before they investigate?
No. In the investigation, this is crop up. They look into it. But if there is no shred of evidence towards that direction, they won't begin to look towards that particular direction unless there is evidence. So if there is evidence, they look into it and, okay, maybe money passed on. But there was no such thing. Or there may have been such, and they discovered that there was no such evidence towards that. So I give them that particular.
The other matter is that when they say the matter was not properly addressed, is also when they highlight that they say, look, the issue has not even been properly addressed because the principle for plea bargaining has not been either itemized or highlighted. Because if they say that they agreed with the consent of the judge and he gone ahead and did something else, which some argue it was within his jurisdiction or his discretion, the criminal code, the penal code, all of those are still there the way they are. It means the same thing can happen. Unlike in Lagos, where if you're going to do this plea bargaining, it has to be written out.
That's right.
But then in that case, it's not the same case.
Yeah, I have said it before, before now, that we don't have any of the national laws that deal with this issue of plea bargain very, very comprehensively. Set out the parameter under which we apply it. It has been the issue of rule of the thumb. It happened with Igbinedo's case. It happened with this woman.
Because it was not.
Because it's not written out. Now, even at that, and that's why people are clamoring that we should, get it written down properly so that it wouldn't be on the issue of rule of the thumb. It should be properly spelled out. But even at that, it has been applied in some of the decisions and we see abuses. But in this particular instance, why people are clamoring that this was wrong was the issue that they even agreed on certain things that was not implemented by the judge. They agreed that we're going to drop all the charges and probably go on with only one charge, section 308 of the penal code. We agree with that, which has a maximum punishment for 2 years. And so the man must be given custodial sentencing. It was agreed. He returns so properties. He returns so amount of money. It was all agreed. Are you following me? A judge came in to seal it. because they must have initiated the discussion between the prosecutor and the defense before coming to the judge. The judge plays a role. The judge will look at the entire thing. Oh, does this serve the interest of the state? And goes ahead and says, yeah, it does. And then makes a pronouncement. Now, they have all agreed. But the judge now departed even from the agreement, even though there is no written law that says these are the procedures.
That's the point. If it were written,
yes.
do you think he would have been able to...
No, if it's spelled out, he wouldn't have.